Hello, my name is Michael Johnston, and I am a second year here at Bowling Green State University. My undergraduate studies are in computer science with a minor in business pre-law. This previous winter session I studied abroad to Costa Rica with the goal of analyzing the intellectual property rights of both the United States and Costa Rica. First off, intellectual property rights, or IPR, help entrepreneurs, inventors, researchers, businesses, and universities to protect their unique products of thought. These rights, however, may vary between a developed country, such as the United States, and a developing country like Costa Rica. These rights can be better understood by looking at the respective histories of both of these countries as they pertain to IPR. Viewing these histories in conjunction with certain treaties, trade agreements, and organizations can provide a more in-depth perspective on the IPR structure for that country. Lastly, with an abundance of background knowledge, it is important to then understand what the impact such rich history and development has had on Costa Rica over the years. Though intellectual property rights, protections, and procedures vary across the globe, the theory supporting the protection of intellectual property is universal. Consequentialist theory supports the granting and protection of intellectual property in that such protection leads to good outcomes. Those outcomes may be of, but are not limited to, economic, societal, and medical benefit. The ability to grant sole ownership and protection encourages people to develop new art, literature, technology, tools, and much more. The patent process in the United States began in 1790 when Congress passed the first United States patent statute. However, the idea of the patent did not begin in 1790. In fact, the general concept of patents that is still roughly used today began in 1624 in Britain with the Statute of Monopolies. The British system, however, wrongfully granted patents to those who were not the true inventor and charged applicants a large fee. This cost and corruption influenced the Patent Act, which ensured the granting of a patent to the rightful inventor and had a substantially lower filing fee. For the purpose of this research, the final pivotal change in the U.S. system was the creation of the United States Patent and Trademark Office in 1836. To this day, the USPTO remains the governing body of IPR in the United States. Intellectual property in the United States contains the following categories: patents, trade secrets, copyrights, trademarks, and rights and publicity. The following focuses solely on the patent process at the USPTO. In general, an inventor, business, or university will seek the assistance of a patent attorney to help prosecute a patent with examiners at the USPTO. The patent attorney files a patent application with the USPTO to be reviewed by an examiner. When the examiner reviews an application, he or she is looking to see if the claims are, quote, supported by the description, patentable subject matter, useful, novel, and non-obvious, unquote. The examiner will then render an opinion on the claims as to whether they are valid. This circular process of the attorney modifying the claims and the examiner rendering opinions continues until either a patent is granted, the attorney and client rest, or an appeal is filed. Appeals can be filed with the Patent Trial and Appeal Board or the United States Federal or Circuit Courts. Moving from the United States to the international stage, there are three important facets to understand before transitioning to Costa Rican IPR. These are the World Intellectual Property Organization, or WIPO, the Patent Cooperation Treaty, or PCT, and the Paris Convention on Patents, or Paris Union. Established in 1970 and composed of 178 countries, WIPO's mission is to, quote, promote through international cooperation the creation, dissemination, use, and protection of works of the human spirit for the economic, cultural, and social progress of all mankind, unquote. This mission supports the consequentialist theory behind IPR. The Patent Cooperation Treaty, or PCT, which was created by WIPO, is a multinational treaty in which 153 countries participate. it should be considered that the PCT constitutes only a filing process and does not have the power to grant patents. Instead, it aids parties that desire to complete international patent searches and file in multiple countries. The PCT has provided a framework for patent procedure. Much of this framework helped to change and re-establish Costa Rican law surrounding the topic. Many of these changes have occurred within the last 20 to 30 years, as Costa Rica only recently joined the PCT in 1999. Though the procedure is well established in Costa Rica, the understanding of the procedure and use of it by Costa Rican academics, business people, and citizens remains limited. With new PCT guidelines, the data points to slow adoption by Costa Rica of the PCT. Patents filed under PCT guidelines were 2 and 4 respectively in 1999 and 1998. After the first 2 years, applications under the PCT increased to 159, 196, and 217 in the following 3 years. Of those applications, still only 28, 21, and 24 were granted, which is within 10 of the average number of patents granted in years leading up to the implementation of the PCT. Created in 1883, but not joined by Costa Rica until 1995, the Paris Convention on Patents is listed by WIPO as a global protection system and has provisions that ensure applicants are to be treated as nationals to each country in the Union, filing in any of the Union countries gives priority over other patent applications outside of the Union nations, and that common rules provide general guidelines for how intellectual property prosecution should be handled. Overall, the Paris Union allowed Costa Rica to adopt common rules, and the PCT helped them to adopt common procedure. However, prior to joining the Paris Union and the PCT in the 90s, Costa Rica had already developed a rich intellectual property history. Equivalent to the USPTO, Costa Rica's National Registry began in 1889, and it currently oversees livestock marks, trademarks, and patents, with similar constitutional protections stating, quote, "Any author, inventor, producer, or merchant shall temporarily enjoy exclusive ownership of his work, invention, trademark, or trade name in accordance with the law," unquote. The process is also very comparable to that of the U.S. In Costa Rica, the process consists of the application, formal examination and publication, third parties' oppositions, and examination and decision. There are some key differences and similarities that exist between the U.S. and Costa Rica. One major difference is that, without attorney fees, the cost of patent application in the U.S. is well over $1,000, while Costa Rica's comes in at around $500. Another interesting difference is that Costa Rica holds cattle branding under trademarks in the National Registry, while in contrast, the U.S. has similar provisions but delegates it to the state legislative authority. Lastly, the number of annual patent applications varies widely, with the U.S. having thousands and Costa Rica only having a few hundred. Similarities include that in both countries an attorney is highly recommended for patent application, but in the U.S., a certified patent agent also suffices. Additionally, aside from having similar definitions and processes, the United States and Costa Rica both divide patents into 2 comparable categories. In the U.S., they are defined as utility patents and design patents, and in Costa Rica, they are defined as product or process and minor invention. These categorical distinctions define the differences in both countries between a major and minor inventive step and the protections that come with them. Now understanding U.S. IPR as well as international agreements, it is important to view IPR from solely the Costa Rican point of view. The trade-related aspects of Intellectual Property Rights Agreement, or TRIPS, affects the business side of intellectual property. In contrast to the Paris Union and PCT, which were developed by WIPO, the TRIPS agreement was developed by the World Trade Organization. The Costa Rican IPR timeline begins to piece together when it is observed that Costa Rica joined both the Paris Union and TRIPS in 1995, and it begins to explain why Costa Rica did not join the Paris Union until some 100 years after its inception. The push for TRIPS stemmed from U.S. pharmaceutical, agrochemical, electronic, software, and entertainment industries who faced threats from foreign competitors. Those in favor of TRIPS felt that the agreement would increase foreign direct investment and technology transfer. Those opposed felt that these IP rules could also slow industrial development by constraining opportunities to copy and adapt technologies. TRIPS has performed well in the eyes of some. The analysis of TRIPS' success, however, is dependent upon the researching body's perspective, as the agreement was highly influenced by global politics. Though Costa Rican national patent applications did not increase, one study found that, quote, a stronger protection of property rights increases technological transfer from the north to the south of the world, benefiting the less wealthy economies, unquote. Thus, the TRIPS agreement and its imposed standards may not have bolstered innovative activity within Costa Rica, but it may have helped to introduce the country to new technology from developed nations. CAFTA is a free trade agreement that includes the United States, Central American countries, and the Dominican Republic. A free trade agreement initiated in the beginning years of President George W. Bush's administration. The Office of the United States Trade Representative lists, quote, facts of CAFTA as, quote, strengthening workers' rights and conditions in the region, and promoting prosperity and stability and opportunities for citizens within their home country, unquote. It was passed in Costa Rica by a narrow margin in 2007. Joining CAFTA also meant joining the International Union for the Protection of New Varieties of Plants, or UPOV. UPOV allowed for seeds and living organisms to be patented, and it introduced both farmers' and breeders' rights. The contrast between farmers' and breeders' rights is an attempt to commodify biodiversity. It becomes questionable as to whether the commoditization of seeds and a battle between small farmers and large corporations for the IPR attached to them is representative of the, quote, home country prosperity, unquote, that the Office of the United States Trade Representative ensured. Prior to the implementation of CAFTA and UPOV, in 2003, 3 researchers from the University of Costa Rica, Ana Espinoza, Anna Sittenfeld, and Sylvia Salazar, published an update to their research concerning the development of transgenic rice and its relation to IPR both nationally and internationally. Rice accounts for 25% of the daily caloric intake in Costa Rica. These researchers developed a rice strain that was both virus and herbicide resistant to help support the growing need for more rice. Prior to UPOV, patents were not permitted on biodiversity. Thus, the researchers did not believe there would be an issue at the national level. However, they recognized in their paper, quote, should the rice be exported, negotiations for commercial licenses with rightful holders of proprietary inputs and technologies will be needed, unquote. They recognize IPR as a necessary evil because for researchers in developing countries, the monetary gain that they can see out of IPR can fund more research. However, it limits the way and rate at which ideas are exchanged. In Michael Heller's The Gridlock Economy, written after the implementation of UPOV and CAFTA, he mentions the plight of these researchers at the University of Costa Rica. Quote, before the university can sell the seeds to farmers, it must get clearance from the holders of as many as 34 patents. Though it does not appear that the plight of Costa Rican IPR as a developing nation is a good one, hope and progress can be found through a recently formed organization, the Ibero-American Program for Industrial Property and Development, or IBEPI. Developed in 2011 with the financial backing of WIPO and consisting of 14 member countries, IBEPI has 4 main goals: strengthening intellectual property in the research and business sectors, disseminating technological information as a tool for innovation and development to all member countries, coordinating the sharing of best IPR practices between member countries, and reintroducing Spanish and Portuguese as technological languages. IBEPI has taken 2 major steps towards achieving these goals. The first, Symposium, is a support platform where small and medium businesses can locate trainings, IPR application process information, up-to-date IPR news, and individual assistance. The second program, Infotech, is a collection of informational bulletins, quote, with the aim of establishing a bond of mutual benefit and with a commitment to constant maximum improvement, unquote. Upon review, the assortment of information that Infotech provides to businesses and entrepreneurs effectively breaks down relevant information by industry, including but not limited to agriculture, wind energy, and information technology. United States IPR build a foundation of understanding. International IPR conventions and agreements such as WIPO, the PCT, the Paris Union, and TRIPS bridge the gap to lay the foundation of understanding for Costa Rican IPR. Trade agreements such as CAFTA and UPOV have had a large and potentially negative impact on how Costa Rica views its IPR. With rapid and frequent changes since the turn of the century, Costa Rica has been able to remain poised and ready to continue growth and development, especially with the backing of organizations like IBEPI. Upon analysis, intellectual property rights within Costa Rica are still developing along with the rest of the country. Since its acclamation to the world stage in the 90s, Costa Rica has made good progress in both the business and research areas. Not having had as much experience on the world stage as other countries, it does seem that Costa Rica has been taken advantage of in some trade agreements and international organizations. As seen in both the example from the University of Costa Rica and the development of IBEPI, research and innovation continue to grow within the nation, and the number of annual national patent applications continues to rise. With the collective power of IBEPI behind them, Costa Rica is poised to become a world player in IPR in due time. Additionally, with room to continue developing, their national registry has room to flex and grow as it needs to before becoming inundated with applications and administrative processes. Though the United States and Costa Rica are very comparable in terms of policy and procedure, the difference lies in their relative influence and where they fall on the timeline of overall development. Thank you for taking the time today to listen to my research findings. I hope that not only did you learn something new, but that you also may have a new perspective on intellectual property. Should you want to contact me, please feel free to email me at mwjohns@bgsu.edu. Again, thank you.